Um, while we all hope that these types of things go well when you bring on a new shareholder, sometimes they don't. How do you manage exiting an underperforming shareholder employee? What are some steps that you could take to do that, and how would you manage that process?
Yep. Without sounding like a broken record, it's again about having proper agreements in place, and that's your shareholders agreement and your employment contract. So this is a big one that my clients are always concerned with, and particularly with minority shareholders as well. You know, what if these people come on board and they're just not performing as an employee and not performing in the management role that you foreshadowed them in? You know, putting aside employment law, we're not going to cover that, but that's just dealt with in the normal course as an employee, and that's why you want your employment contracts with any KPIs and duties and everything like that really sound. But how you actually exit them as a shareholder is dealt with in the shareholders agreement.
Yeah.
So how I like to do it is put in what I call trigger events, and basically that means if X occurs, you as the majority shareholder would have the option to buy the shares back off the exiting shareholder and force a sale. And X event might be their employment's terminated, or they leave their employment before the minimum 4-year commitment period that they've provided under the shareholders agreement. So they're sort of trigger events, and you can dictate within the shareholders agreement how the buyback will occur. And if they're bad trigger events, such as dismissal for misconduct or something like that, you might decide that, well, they shouldn't be entitled to the equity growth in the shares that they've had, so you'll buy back the shares at the price that they paid.
Yep.
If it's, I guess, a good trigger events, and also, if an employee suffers permanent impairment, or after this minimum sort of 4-year commitment period, for example, they decide to go their own way, which is fair enough. They've given you 4 years of their time. Yep. You might say, well, you deserve to get that equity increase, and that you'll buy back at market value. So there are various ways you can structure it, but again, it's depending on the matter, depending on your individual view of how you want to structure it. But that is all dealt with in the shareholders agreement, and we sort of provide advice to our clients on various options, and it's up to them how they actually want to proceed. But without the shareholders agreement, you can't force the sale of shares without, as you would know, going to court. So getting those shareholders agreements in place at the beginning is paramount to avoiding disputes. You can put certain KPIs and performance evaluations in the shareholders agreement. Yep. Because the shareholders agreement is not, I guess, governed by the employment laws. It's more of a contractual relationship. So, you can put in there, if you don't meet certain KPIs, that's a trigger event to force a sale, sort of thing. So, the sky's sort of the limit, subject to laws of oppression. And
that's right. Yeah. Something else that I've seen in some shareholders agreements is a sort of a probationary period for a new shareholder, where the majority shareholder might say, well, listen, I'm going to give you 12 months or 2 years, and if in that period I decide it's not working, then we'll basically undo the transaction, give you your money back, and I'll take my shares back, and everyone can go on their way. So that's something else that you can do to sort of maintain a little bit of control and give everyone an easy out if that comes up.
Yeah, that's right. And so the shareholders agreements are very important, and
absolutely,
worth spending the time and getting it right.